Barker is absent. Bonnet. Fox.
Here.
Calth. Kennedy. McPherson.
Here.
Morgan.
Here.
Pendrell. Plucker. Prestai.
Here.
Quinn. Reddick.
Here.
Salgado. Sotolongo.
Here.
Kratz.
Here. As required by the Open Meetings Act of the state, we have a copy of the Open Meetings Act on the wall to my right. If anyone wants to review it, they're welcome to do so. We need a motion to approve the minutes from the previous meeting. Those minutes have been sent to everyone.
McPherson, I move that the minutes from the, what was it? June 30th meeting of the Charter Convention be approved as submitted.
Fox, second.
Okay. We don't need a roll call. Okay. Guess we'll do a roll call.
Bonnet. Present. Yes, I need a yes or no. Oh, yes. Fox.
Yes.
Calth. Yes. Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell. Yes. Plucker.
Yes.
Prestai.
Yes.
Quinn. Yes. Reddick.
Aye.
Salgado. Yes. Sotolongo. Yes. Kratz.
Yes.
Motion passed 14-0.
We'll go to the next item, which is consideration of charter amendments. With that, Mr. Endenbosch will present the first one.
Talk louder. There you go. All right. As a preliminary matter, they were controlling, mine didn't control it. I do want to offer, or I received 2 items today. People asked that I place them on the record. The first item, which has been marked as Exhibit 1 and will be provided to the reporter, is an email from Jason Huff, who's the owner-publisher of the Daily Record, in regards to Section 811, which is actually not a section that will be before you, and I will provide that. And then as we get to the first amendment before you, which is Charter Section 6.11, and obviously we talked a fair amount about this particular section last month, and I'm not going to reiterate that discussion, but I was asked by Ms. Bonet to make an email that she sent early this afternoon part of the official record. That has been identified as Exhibit number 2 and will be made part of the record that is maintained by the court reporter as well. That being said, obviously we've had some discussion. I know Mr. Wiesen has addressed Section 6.11. In my view, it's open for you guys to have discussion, and I know it was laid over from last meeting, in part, frankly, to let Mr. Pendrell and Ms. Bonet, who are both part of the HR committee that suggested it, an opportunity to address it. So obviously, I think it's appropriate that they do so.
Okay, with that, we'll open up to a public hearing. Seeing nobody, public hearing's closed. Discussion on section point 6.11.
Since I sent the volume of information in the email today, I apologize for it being late, but I was late arriving home from vacation and was trying to play catch up. As you can tell by the email, I'm very passionate about it. And I think it's something that we do need to pass on to the City Council for consideration. The points that I make, I believe, are things that are is referencing specifically the action by the chief, the police chief, in this last primary. And in order to respect the office that the police chief holds, and him, I respect him as well, I do believe that we need to have something specific and written in the charter that limits the amount of political activity that the employees who have civil service protection, which would be, in this case for public safety, the police chief, the fire chief, and the city attorney, so that people don't feel intimidated by those 3 pillars of our legal system: law enforcement, application of the law, and judgment of the law. I think that we can take a model of conduct from the Code of Ethics that the Supreme Court of Nebraska uses regarding judges and their ability to support, to endorse other candidates for different offices. It's a matter of ethics because they're very powerful offices and they are very powerfully impacting our community. So it's all written out there much more neatly than I just said it. But I do believe that we need to move on the amendment that the HR subcommittee came up with. And my reasoning is expressed there in the email. If anyone has any questions for me, I'd be happy to answer them.
Kennedy, I would like to speak on that. One is that I have huge concerns on the First Amendment rights of those positions to be able to state who they support on their free time. And I did have a chance, and I respect your opinions, Ms. Bonet, regarding that you think it's a 24/7 job. In many ways it is, but they have downtime, they have their opinions, and they can say, based upon their experience, who they believe who's right for office. And I have concerns is because the chief did do that. Is it because he endorsed Mayor Stothert? What if he endorsed the other candidate? And we get this coulda, shoulda, woulda. I don't want to limit a chief, whether they support a Republican, a Democrat, an independent. It doesn't make a difference to me, so long as, one, they're not wearing the official Omaha police uniform, which is handled by state law, I believe, and two, not during city time or time that they're on the clock. But if it's outside the event and they want to weigh in on an election, I think you have a right to do that. I've taught constitutional law at Creighton and at Metro. I think you're inviting a lawsuit because someone will probably want to test that down the road. And I think this, as a member of the bar, this is different than judges. Judges are to be non-biased, not seeming to be involved. That's the nature of their position. They're specifically excluded from participating in the election process, and for good reason. We're a Missouri Plan state. We have our judges there. They're voted in out of, or they're put into office by a governor, and then they're ratified every 6 years on the yes or no retention basis. We don't have them elected like they do down in Texas and run against other people. That's wrong. It's a much different type of deal between a judge and them making endorsement if you're a police chief or a fire chief. Last point is this is, because they have that experience, if they feel someone is not being safe and someone's not protecting the city or has plans that do not protect the men and women that serve in the police department, fire department, and other areas, then I think they should be able to tell the public that, because then basically you're putting a muzzle on that person. And I think the public is not intimidated by the police chief, because the police chief isn't going to go to their door, beat it down, take names and all that. But I think what you get from the police chief is people can weigh it. Some people weigh the opinion. I don't believe in this police chief because, and I'm not saying this about Smotter, but this police chief hasn't done right by the community. This police chief has a problem of sweeping things under the rugs and things like that. If you had that type of police chief in your community, then you'd probably say, I'm not going to go with this guy's opinion. So I think the voters in Omaha are pretty savvy, whether they support or don't support what this chief is. And by the way, when we put things into the charter, we're not trying to address a single person. We're trying to address any person that holds that office. And so I just hope we're not doing this because we may or may not like what the current chief did or didn't do.
I would like an opportunity to respond to that. It is not personal. It is not Chief Smotter. It is an issue of protecting that office and making sure that the citizens of Omaha feel that they can trust that there will not be undue pressure or undue influence from that office for a specific election. And, you know, the chief is a 24/7 job. It isn't a punch-in, punch-out type job. Even when he's on vacation, he's on call. So the average citizen, in my part of town at least, East Omaha, does have a concern when a powerful person steps forward and suggests another powerful person for a job, for an election specifically. It is not against an individual. This is for the protection of the integrity of the office. And it includes the other two civil service appointees.
Cal, I would like to address the powerful person stepping in to influence powerful people. Then you have to describe and define what is a powerful person. I think we start getting into the weeds. I do think that this is a First Amendment right. Someone who signs up to do a job should not be expected to set their First Amendment rights at the door and never ever do them while they're doing the job. So I think we have to be really, really careful when we start talking about powerful people, because there's no real definition of that.
I would add to that if I could. I mean, powerful person in a powerful job. I mean, the chairman of the board for Kiewit, the president of Gallup, someone on the board of directors. I mean, the chief is the chief of the fire chief. They are individuals at the heart of it. They have opinions. They can do their job and still have their own personal opinions and their right to free speech. And I would echo what Mr. Kennedy said. This is a constitutional right, and I don't think we should limit that. I do think we should limit, as it is in state law, that a person should not wear their uniform, whether you're fire chief or police chief, and you should not do it on, your business hours.
I'll only note that the uniform prohibition frankly already exists in the charter, as well as state law, obviously.
This is Anderson. I just had a question, and other than the people on the charter, with affordable housing, we had numerous public comments on it. With this particular agenda item, 6.11, how many public comments did we receive on it other than within this charter community?
I believe we received approximately 22 comments, and I believe there was one of the people that communicated that expressed a similar, I don't know that it's the exact same thing, but a concern that's close enough that I would say it was similar to this particular concern.
Thank you.
Any other comments?
Well, I would like to say that I heard from many people, and they put their trust in me to come forward and make the statement. This involves three very important, very influential people who have civil service protection, which means there's little recourse other than a complaining session to address issues that may arise. A lot of people that came to me and said they were concerned about what the chief did as far as specifically recommending one individual. So the kind of numbers that you want to count, it all depends on how you count them and who you count them from. So that one complaint, or the one that supports the idea of a concern about the police chief, could be representative of hundreds of people. In the nonprofit realm, they say that if there's one person who speaks up, you can count on it being representative of 1,000 voices at least. So free speech is free speech, and in private, in small groups perhaps, but coming on the television, everybody knows you're the police chief, everybody knows you're the fire chief, everybody knows that you're the city attorney. There is a lot more clout behind your voice than if you were just Joe Schmo off the street. And people are intimidated by that.
Sotolongo, I would alternatively say there's people that are comforted by the experience that someone in his position would have to give an endorsement, which is something that many people in positions of authority and power and experience and credibility give to candidates all the time. I don't see how it's different from the mayor giving an endorsement, personally.
Any other comments? I'm sorry, go ahead.
So I have a question for Mr. Kennedy on the enforceability of this. And feel free if you don't feel like you've studied enough to answer this to pass, Mr. Kennedy. But thinking through a hypothetical, if a future, ex department head that was referenced in this says that they're personally supporting a candidate, and then a PAC or a campaign were to run and say that, Chief X endorses this candidate, Is that the exact type of concern you have in terms of opening it to a lawsuit and really making something like this even tough to enforce?
Well, you said X. I think the thing is a current fire chief, or police chief.
I'm thinking like Chief Smith, I guess, you could substitute in Smith or whatever name you want
So
for
let's
it.
just say, so if they're a current chief, whatever their hat they wear, I think you have a problem because, well, I think someone can repeat saying, hey, this is a person, let's say Mayor Smith is supported by all these public officials. There's nothing wrong with that. But I think where you have the legal hoop possibly is that if the city wants to sanction an employee, let's say despite whatever's in the charter, future Chief Smith says, no, I'm going to endorse Chief Jones or Mayor Jones, and I think Mayor Jones is doing a good job, and they try to fire him, well, then that's an employment scenario, and that may or may not happen. I mean, you've seen a lot of these cases employment cases where people are kept on the job because they have a constitutional right. One was that coach kneeling out in the middle of the field and all that. I mean, ultimately, that's a litigated issue, and all I'm telling you as a lawyer that's seen a lot of cases with free speech, and I've taught this area at the School of Journalism at Creighton and at Metro, free speech is a First Amendment right. That's one of the main important rights, and you got to have a reasonable basis to curtail that sacrosanct right. And I just don't see how the city has the ability to do that if they're on their own time. But if Chief Smith did it, like at a city council meeting during his work hours and said, I support this person for office, then they have violated their job because they're not supposed to do that or wears their uniform. So those are just my 2 cents.
So, and maybe I'll address it.
Does the law department want to weigh in on this?
Well, I'll address it a little bit, and my answer is going to be a little bit squishy because I think the answer by necessity is a little bit squishy. There is no question there's a First Amendment implication whenever you're looking at a charter amendment that would potentially limit the people to endorse, and there are plenty of cases that have said your ability to endorse somebody for political office is a First Amendment issue. That being said, there are abilities to put reasonable limitations on free speech. And I think the open question is, and I don't think we've found a case that's on point that we would say this is going to give you the true and correct answer. There's no question under federal law, there are some actions, some particular employees who are employed in the federal government that it is illegal for them to endorse a candidate or not. In this particular case, I mean, obviously the argument that we would make if this were to be adopted and a future police chief, fire chief, or city attorney were to complain that this was somehow inhibiting their First Amendment right to speech, we would talk about the fact that a lot of the things that have been talked about by Ms. Monet, we have 3 positions that are here. These positions, by the very nature of their job, have a certain amount of trust that's given to the position, and because of that, it gives them a potential candidate an unfair advantage. And that's going to be a test that a courts would end up having to apply. And if I felt there was a definitive answer, if I felt there was a court case that was precisely on point, we would have brought it to you. So there's no question it implicates that potential right. I don't think we can stand up here, and I know Ryan took a look at this issue as well, and say that we think it's a violation of the First Amendment if you adopt it, or could we say it would necessarily survive a First Amendment challenge? The reality is First Amendment law is very fact-specific, and that's what you'd have to do here, and you would weigh the compelling reasons, some of which I think Ms. Bonet has expressed, and you would look at also whoever was the one desiring to give the speech and their right to be able to articulate their views, and ultimately a court would decide. But as I said, it's not unprecedented in government to have particular positions where your First Amendment, where the courts have upheld limitations on First Amendment. Now, that's generally been at the federal level. But in any event, I don't know, that's somewhat of a squishy answer, but because I don't have a definitive one, but that's the analysis that would have to take place.
Thank you. Any other comments? Yes, sir.
Yep, Tim Pendrell. Yeah, my read on it was like the final sentence where it's specifically not, doesn't prevent anybody from casting an opinion or casting a vote, but the intent was really within the service of the city or an appearance of being service in the city and on duty. When we were going through this and seeing that it was while on duty and spelled out mayor and city council races, but not other political races, I've never had a job that's allowed me to do any politics while on duty and in service. And then making sure that the chiefs in the civil service protected jobs are included, even on the as part of the cabinet, is just as much a way to protect them, because being civil service protected, they are protected from politics. They can't be fired for any reason whatsoever, including their political opinions. So it's, be careful about the wording and making sure that it's, the intent is correct, that it's really, focusing on while on duty, in service, and looking at elections here and there and personal freedom of speech issues, but protecting both sides, both to protect the civil service protected staff, but also it's really need to focus on in duty and while in service, which I think there's a lot of language in the overall section that points that out, but making sure maybe we're very clear in what we mean. I think that's about it.
Thank you. Any other comments? Was there a motion?
I have a question for Ms. Janet. Chief Smith, we'll go back to Chief Smith. I like that name. If Chief Smith's wife or spouse were at said event and said, and I quote, "Our family supports this candidate for any list of reasons," and the chief did not say those words, that would still lead the public to the same conclusion, and there's been no First Amendment right of the chief that has been violated. Even if we were to put this in and that happens, it defeats the point of putting it in. Like if we go through this exercise and we put that in and we know from what the legal department has said there will be challenge, there would be an easy workaround. The family just says it on behalf of that person. If we're going to go through this exercise for any and all amendments, even the other ones that are up today, they should be that there is not an immediate workaround, and it kind of voids the work we've done here. So I'm not saying that this is bad on its merit or that you don't bring up some excellent points. You do. There was a lot of heated discussion when I brought this up to other people, because it was discussed in the last meeting, and they said, well, even if you put the law in, even if you tried to change it, what keeps that from getting worked around? So why would you waste your time? And so I'm asking that question. Have you thought about any other workarounds or any other way in which we don't hurt someone's First Amendment right and we are able to get done what you believe is a necessary step?
Yes, I have. And I believe that the description that I give in my email regarding the judges and the sites that you can go to, I gave a link there, that you can see it's not complete stifling of an individual's ability to express what they think. It's controlled. It's based on a broader number of factors than what you might think of a wife working around this action. And I don't think that creating a series of hypotheticals that would nullify the value. It's like, oh, well, why should I vote? My husband voted, and we vote for different people, so why should we vote at all? That kind of logic doesn't work in the end in a democracy. And so in order to protect the public, the charter is set to design a government that protects the public and our system of government. When people of influence and power, and though you might be able to say, oh, well, you have to define power and you have to define influence. If an officer stops a young African-American male, is there a sense of intimidation? And where does that culture of intimidation come from? You don't know, anyone here who wants to answer that, but it is a culture of intimidation. And you'll feel it much more than many other people do. I feel it as a woman. So intimidation is not necessarily something you can put your finger on, but you feel it when it happens. And when a person in a protected position, appointed, not elected position, is able to exert influence, it creates a situation of intimidation among those who are not within his circle or her circle of power. So, yes, I've thought about other things, but I don't think we can step away from the question at hand. And using the example of the judges and of attorneys who have their ethical standards, professional ethical standards, and social ethical standards that they respect, they don't use that within the justice system as a means for intimidating. They control themselves because they have to be apolitical in the decision processes that they make. Once they become political, the opportunity for corrupting the purity of a system that we think we have is there.
Cal?
Mr. Reddick?
Oh, go ahead.
Get his light on first.
Actually, I will yield to Ms. Kauth and let her bring her point.
Kauth, my question is, where does it end? I mean, we can say that there are people of power and influence in every level. If you are in a small neighborhood and there's a local police officer who works or lives down the street from you, is that person viewed as having power and influence over you? And do we go all the way down to that level? Defining power and influence and using that as a criteria to discriminate against someone's free speech, I think feeds into a lot of dissension. I think people have a right to ask questions. I think people have the right to make statements. This is very clear that if you are in uniform or on the job, you don't do it. But once we start trying to identify those people who we don't want to speak because we might be afraid of them, that's an endless list.
Okay. Any other comments? If not, Mr. Reddick?
The example you gave regarding if I was pulled over as an African American by a police officer, would I be intimidated? To maybe put a lighter spin on that, that's a Jedi mind trick used on the weak. I do not believe that simply being pulled over by a police officer, having a police officer of any position make any comment is going to necessarily have influence on me unless I allow it to. Whether they're supporting a candidate, a restaurant, a particular road being built, none of that really matters. I think it is on the job of every Omaha citizen, since that's the charter we're looking at, to do their own due diligence regardless of who supports who. I don't think the badge, the uniform, speaks more than the person's character. So if they are of the right character, their position means nothing to me individually. And I think the citizens of Omaha, you yourself being a great example of that, will do the due diligence to decide whether that endorsement carries the weight that we think its position or that person's position might.
Do we have a motion?
May I make a final comment?
Yes.
Closing
Final
comment. Why do we have a special category of employment, civil servant, protected position for the police chief, the fire chief, and the city attorney? I think Mr. Indenbosch might be able to give us an answer.
I certainly deal, this is the world in which I live every day. And most city employees are civil service. That means they keep their job regardless if it's elected as mayor or city council, with certain exceptions. And I think if we go back to the people who framed the charter, there was a decision made to have these three positions have civil service. And what civil service basically means is they're not employees at will. They cannot be terminated at the whim and whimsy of the mayor. They can only be terminated for cause. So by being civil service employees, that means these three particular individuals have the protection to be able to make decisions as police chief, fire chief, and city attorney without having to worry about losing their job, making an unpopular decision that's unpopular with the mayor, unpopular with the council, unpopular with the public, because if someone were to take action against them, they would then be able to appeal and have a full due process hearing where someone had to establish there was cause for them to be terminated or disciplined, and not just somebody didn't like what they said. I hope that answers what you're looking for.
Motion?
I'll just follow up. I did find out that one of the reasons that those positions, I don't know about city attorney, but the chiefs being civil service protected is because it was the elimination of the public safety officer a really long time ago. And when that was removed and the chiefs moved up to the cabinet, that position was not civil service protected. It was at the will of the mayor. So that's, I believe historically that's how it actually happened, that those positions ended up being separated from the rest of the cabinet.
And I will tell you from the city attorney's standpoint is you make, give opinions to both the council and to the mayor. Sometimes they don't like them and just soon get rid of you. And sometimes, yeah, that's why with the city attorney. And I've been in that position several times, as Bernard has too.
I might have had a mayor or two that didn't like a decision I made and tried to get Paul to get rid of me once or twice.
Okay, do we have a motion? Either motion to approve or motion to deny.
I make a motion to approve.
Okay, is there a second?
I'll second.
Okay. Let's do a roll call.
Bonet.
Yes.
Fox.
No.
Kauth. Kennedy. McPherson.
No.
Morgan.
No.
Pendrell.
Yes.
Plucker.
No.
Prestai.
No.
Quinn.
No.
Reddick.
No.
Salgado. Sotolongo.
No.
Kratz.
No.
Motion fails 2-12.
I'd like to thank the board when they voted for us to have the opportunity to do the debate. I appreciated that very much. I watched you all. You're very photogenic, all of you. So thank you for the debate opportunity and for the presentation of this information. But I do think we need to take serious consideration in the future, again, on this topic. Thank you.
Let's move on to the next issue, next item. And Bernard, that's section 2.07A. Is that correct?
And I apologize, I should have said this at the beginning because I think Ms. Bonet actually asked me to remind people of this and I forgot till she just spoke. We've obviously recommended a number of amendments already in the past and there's more before you. Just to remind everybody about the process is those will go to the city council. What has typically occurred is there's been a legislative subcommittee of the city council that will then consider the proposals that they've received from you, and they will select some or all of those items to go move forward to the city council for consideration. And if the city council were to approve them by an ordinance, then they would be placed on the ballot. And I know we talked about that early on, but my guess is now that you've been engaged for a period of time, it's for some people might not be a bad reminder. That being said, I'll move on to items B, C, and D that are before you. B, C, and D are the language that was before you last month. I made a couple. I hope I prepared what I think you guys were looking for. So I'll go through them. B, the item B
Bernard,
is.
just wait a second, before you go on, I've got one item here that's just 2.07A,
Yes.
and then I've got another section, 2.07, that has A, B,
Yep.
and then there's a third one.
That's.
Let's see, are you going to talk about those?
I'm going to talk about all three.
Okay. Thank
So the item that's first on there is just an amendment to 207A. And that's the original recommendation by the administration committee that was based on the request by the mayor. And that, as you'll recall, currently when the mayor is absent from the city, the way the charter is currently written, the mayor has to inform the city clerk, and the council president then acts as the mayor. This particular amendment, I believe the mayor actually asked for 10 days. The administration committee made a recommendation that those short absences did not necessarily mean turning over the responsibilities to the city council president as acting mayor. So the limitation that was originally put in was for a period of, if the absence was for more than 5 business days, or if the mayor requested the president to act as mayor. Could be a situation where maybe the mayor's only out of town for 2 or 3 days, but maybe knows they're unavailable or doesn't want to necessarily have the responsibility of being mayor of the city. 3 is disabled, or 4 as is provided in section 306, which I think means they're dead or incompetent and unable to perform it. In those situations, if it's less than 5 days, unless the mayor requests, then the mayor would continue to serve as mayor and the council president doesn't act unless that time period is passed. I didn't make any edits to that particular change between last meeting and this meeting. You will see that I did relative to the next 2. The next particular element uses the exact same language in 2.07a in regards to the 5 business days that I just described. What section B does is it changes the current process for determining that the mayor is disabled and creates a process that mirrors the 25th Amendment to the Constitution. And we talked a fair amount about that last month. And then as we had that discussion at the meeting last month, I think it was Mr. Kennedy that indicated there was probably a need to recognize that there may be some emergency situations where if the mayor were absent less than 5 business days, but there might be some situations where if an emergency exists in the city, we may need to have somebody act as the mayor. So what I did in the part that's highlighted, which is the addition of 2.07a, and if it's color printer, you can see the highlighting. If not, it probably looks a little bit gray. Provides that in any situation where an emergency exists, where the peace, property, health, safety, or morals of the community are endangered. That's language that's taken out of 8.13 of the charter. So I went to find another section of the charter that defined what an emergency was and used that language. And then keep in mind that this is an and. The mayor is absent from the city for a period of 5 business days or less, contemplated by this particular section. And 3, the mayor is unavailable by telephone or otherwise for a period of 2 hours, then the president shall act as acting mayor. So in order for this particular emergency provision to apply, all 3 of those things have to occur. It has to be an emergency. The mayor has to be absent for a period of 5 business days or less, because obviously if it was 5 business days or more, the city council president would already be the acting mayor. And then the 3rd condition is the mayor would have to be unavailable. I used the 2-hour time period because I think that's the time period that was discussed by the charter convention. So that's the addition that I made to what was the 2nd amendment. Moving on to the 3rd one, which is amending Charter Section 2.07 and adds a new section 3.04.5. Kind of started off, kind of came from the discussion about potentially having a deputy mayor, but that kind of morphed into something a little bit different. And what this particular section does is the time period is not 5 days, but it references you to 3.04.5, which you'll see when you look at that as for a period of up to 15 days. Keeps the changes relative to using the model of the 25th Amendment for purposes of disability. That's one change from the meeting, what you saw before you last month. And then the second change was consistent with what we talked about before. As you'll recall, 3.04.5 provided that if the mayor was absent from the city or temporarily unable to perform their duties for up to 15 days, and I know there's a typo there which I will fix, for a period of up to 15 days, the mayor can appoint a member of their staff, a cabinet member, as defined by Section 308, which lists all the cabinet members, or city council president as acting mayor. So basically, this would allow the mayor, as the person who leads the executive branch for short absences, 15 days, for a period up to 15 days, to appoint another member of the executive branch to serve in that particular position. And then what it does is we try to mirror the emergency language that Mr. Kennedy suggested by adding, again, that same peace, property, health, safety, morals that appears at another location in the charter. The mayor is absent for a city up to 15 days, so again, mirroring the time period. And third is unavailable by telephone. In those particular situations where it's a true emergency, you would have a position where you would go back to the president of the city council being the person who's the acting mayor, and if the president of the city council wasn't available, then the vice president is the acting mayor. I think the idea being is if an emergency situation, now you're going back to an elected official, albeit somebody from the legislative branch, would be the person who acts as mayor. So that's what the amendment to number 4DI intends to accomplish. So hopefully I didn't make it more confusing by trying to describe it. So happy to answer any questions.
Well, it is somewhat confusing. What I think we'll do is have a discussion on all of these as Bernard presented them, but then at the end, we'll vote on each one individually. Okay, comments?
Kels, I just have a question. How does the mayor come back? If is it spelled out anywhere that when that person returns, or, I mean, I don't see it listed anywhere how they take their power back.
Well, I think because the contingency is the mayor is absent for the city or temporarily unable. As soon as the mayor is back in the city or able, it would automatically return.
I believe isn't there a part of it that says, unless the city council majority votes that they not come back in after an emergency absence?
Well,
or am I confusing the segments?
So that is the provision if the mayor is disabled.
Disabled.
As opposed to absent from the city or temporarily unable to do it. And it's a different condition, but yeah, there is under that language that mirrors the 25th Amendment, there is an ability for the city council ultimately to make the determination as to whether the mayor is disabled.
Other comments? Okay, let's take the first one, section 2.07, which is short and just deals with being out of town for 5 business days, was disabled, and the mayor should notify the clerk. Is there a motion on that?
Reddick here. I motion we vote on the amendment as prescribed.
So motion to approve.
Is there a second?
Quinn, I second.
Let's do the roll call. Okay, I was reminded we didn't do a public hearing. So, anybody from the public wants to discuss this item?
Luis Jimenez, 2709 Dewey Avenue. I'm sorry to interrupt your process, but I'm kind of disappointed, honestly, that this is happening this year. I thought that the Charter Convention was going to happen 2023, and I have not really focused on your guys' meetings. I really wanted to participate during the Charter Convention, but I thought it was going to be next year. I feel this has been rushed through. I'm sure all of you are tired, a little worn out on this, and that would be a big reason why you would want to have more time for this convention. Having said that, though, I appreciate the opportunity to speak before you guys. I'm not going to stay here through through this whole meeting. I just want to say that that I am concerned with power here in Omaha. We've seen examples of power outside of the city with the Supreme Court denying women's rights, which was a pure exercise of power. The police brutality that's happened the last few years. But for me, those aren't my fights. But for me, it is, I've seen the mayor exercise her veto power on the budget year after year, which results to the embarrassment of council members. And I think that the mayor should not have a veto power on budgetary matters after she's presented the budget to the city council. It takes 5 votes to overturn a veto. And the decisions that she's made to exercise her veto power has put East versus West, Democrats versus Republicans. So I think that's an inappropriate use of her veto power. I'm not saying she shouldn't have veto power, but I think just on the budgetary matters, when after she presents her budget to the council and then they make modifications, I don't think she should be allowed to veto those modifications.
Okay.
Thank you.
Thank you. There's a motion to approve. Let's do a roll call.
Bonnet,
No.
Fox,
Yes.
Kauth, Kennedy, McPherson,
Yes.
Morgan,
Yes.
Pendrell,
Yes.
Plucker,
Yes.
Presti,
No.
Quinn,
Yes.
Reddick,
Yes.
Salgado, Sotolongo,
Yes.
Kratz.
No.
Motion passed 11-3.
Okay, the next one, if I have this correct, and Bernard, you can correct me. The section, this is 2.07, you have paren A, which is the same as what he just passed. He had language in there. So the significant language would be in B, that deals with, she's unable to perform her duties.
Correct.
So discussion on, or I guess we'll do a public hearing on this one. Thank you. Seeing none, we'll close the public hearing. Discussion on 2.07B.
C,
B.
B. Oh, I'm sorry. I'm sorry. That's 2.7A and B, whatever.
This whole section is
I apologize. I was looking at the agenda.
I would just reiterate, in 2.07B, this is the language that I think replaces the outdated concepts of how to declare a disability for the mayor, and I like what we're doing when we're mirroring what's in the federal constitution, and that's what the subcommittee worked on, and I think I can speak for all of us when I say this language is preferable to the outdated and archaic language from before.
Quinn, so, Ms. Plucker, does this mirror what has already been done? Does the verbiage and the language?
This is new language.
Right,
Yeah.
but is it similar to what is federally stated?
Yes,
or-
yes, this mirrors what is in the federal, I'm sorry, I'm blanking on.
25th Amendment.
Yeah, the 20, and it gets rid of the picking the doctors and the doctor having to examine the mayor, and that language that's currently in the charter.
So it's a similar process by a vote or a declaration as it's defined here?
Yep.
Okay.
Presti, I have a question just for clarification, since there's a lot of very, very similar things being discussed here. So with we just passed, would the only change for what we're currently discussing be to section 2.07B, or would there also be a change to 2.07A that would be in conflict to what we just passed?
I believe they're the same, it's the same
No,
language in A.
it adds that emergency language that this particular item before you, and that doesn't mean you can't amend it if you would like, but this particular item before you includes the language in A, adds the emergency language to 207A, and then makes the changes to 207B. Now, I appreciate you could say it's, I don't think there's anything that forecloses you from being able to recommend multiple ones of these and giving the city council the ability to choose the one that they think best suits and will go forward on the ballot. But I leave that to you. I mean, obviously people can vote for one or more of them, but they are different from each other, but I don't necessarily, I mean, I would be surprised if the city council were to send all three, because they'd be inconsistent if they were adopted. I don't know that a recommendation from you is necessarily inconsistent.
I should have asked that question before we voted, because I wondered that too. So I think we either have to do your proposed B, C, or D, right? Because they're all different.
Well, I think you can make a recommendation.
I guess I'm a little bit confused here. I thought what you just passed on 2.07A is the same that we have in 2.07A here.
No, the 2.07A that was just adopted did not include the emergency language.
I see that now. And I think from the subcommittee's perspective, we liked the 5 business days. After the discussion last meeting when Mr. Kennedy brought up the emergency, I think we thought that was a good idea, and the changing the disability provisions. So I would prefer C on our agenda.
But I guess my point in saying is I think it's up to you to recommend. I don't know that it may be inconsistent if all three were going to be adopted, but ultimately, if you would recommend more than one of these, the city council is going to determine which, if any, they want to send forward to the ballot. If they were to try to send 2 or 3, I would tell them that we're inconsistent.
Bernard, are we allowed to have a discussion between us to say, like, poll each other? I mean, officially would say what we like and don't like and try to coalesce around one. What I don't want to do is this, and I think Julia's picked it out. I don't want to give the city council charter recommendations where we give them 3 and say, you pick the best one. We're here to make a recommendation, so I'm willing to live with what the majority here thinks. I think we're all here doing that. I'd rather go through those concepts. Do you believe that 5 days is the best, or 15 days, or whatever? Work through that. Then go to the next part. How do you feel that you should deal with disability? And then do you feel there's an emergency clause? I think this body needs to talk about what they want to see in it, go through that process, and then cobble it together. I really don't want to send mixed messages to the council.
And that's fine.
And then the council, if they don't like it, they're free to amend it, because that's their job too.
I agree, Mr. Kennedy. I think it sends mixed messages to do different versions of the same.
It's confusing. I'm not sure how to proceed with it.
I can tell you one thing I can do with Robert's Rules of Order. Am I allowed in a meeting to change my vote? Who's allowed to change your vote? Is it the person in the negative or the
person that passes?
Positive.
Prevailing party.
positive? And I'd like to make a motion to rescind.
Or you could make a motion to reconsider and have a second, and then it'd have to be people who made the motion to do it, and then you could reconsider, and then they're all technically back before you.
Then I'd like to make a motion to reconsider as stated by council.
Second.
Discussion? Roll call?
Wait, there's a discussion. Quinn here.
Okay.
So
I'm sorry.
If we rescind this, then we're going to have discussion about cobbling these 3 together for one.
I guess, Angie, the problem we have here is that what I think is I think we, as a body, we should say which concepts do we like and go through one by one. I mean, I'm willing to compromise on whatever I think is best in order for us to get to one recommendation that we ultimately vote on. So talking through is, do we like the 5 days? Yes. Do we like the emergency provision? Yes or no? Do you like the disability provision? Walk through the concepts and then ask it to be passed with those provisions put in there. I guess the best provisions if the body feels that way. Otherwise, I mean, everyone can vote on all 3 or 4 of them, and we can send the council 3 or 4 of them.
Thank you, I agree.
Yeah,
We probably ought to have, A separately, and B separately, and then C separately.
No.
Rather than we have changes in one of these, changes in A and B, maybe it's C itself, but,
Oh, you're talking about the charter provision, not
Yes.
the agenda item.
right.
Right. Yeah, because I was going to say, I mean, all three are dealing with the same topics, and and passing all three of them forward to city councils, like we didn't do anything except give them all the options that we considered. So it'd
Julie,
be,
your committee had it, right?
yes.
Yeah.
So
I mean, no, not, but yes, I'm on the committee, yes.
Yeah, so maybe what you have to do is, if the chair doesn't mind, is have that
You need to turn
discussion.
yourself towards the mic, I
Sorry.
apologize.
If the chair doesn't mind, is if we rescind this, then maybe, Julia, maybe you lead the discussion on the provisions and then get a sense of the body, and then I think we can.
Sure, and I'd open it up to Dewan and Jorge. I
Yeah.
can speak for Mr. Barker. I think via his participation and emails, I think we had a robust discussion within the subcommittee about the mayor being able to leave town for a period of time without transferring his or her power. It was proposed 10 days on the subcommittee, and we had a member of the public that sat in. Maybe that's too long. I personally, I don't care if it's 10 days. I don't care if it's 15 days. I think there is a period of time that's appropriate, especially with Mr. Kennedy's discussion about the emergency provisions. So we settled on the 5 business days, giving sufficient time for the mayor to go out of town, not have to transfer his or her powers. We also had a good discussion, I think, about and then I would add Mr. Kennedy's discussion from last meeting about the emergency clause. That's how that section got in there. We also had the discussion about the disability. We think the current wording is archaic, unworkable. I think we felt comfortable modeling what the federal government does. That's the provision you see here in front of you. I would pass the mic to Mr. Reddick to discuss option D on our agenda, which is that concept of an acting mayor, a deputy mayor, which we don't really have in the city, but this was his idea to have the mayor choose his or her, who's in charge when he or she is out of town. But those are the three
Well,
ideas.
And just so that everyone recalls the last meeting, as I recall the discussion at the last meeting, it was, Bernard, why don't you come up with 2 alternatives based on our discussions? And the 2 alternatives are the one that, and I'm going to refer to it under the agenda as 4C1 and 4D1. Amendment 1, the first alternative was the one that had the 5 business days, the emergency, and the change to the disability. That was kind of alternative 1 that my understanding, trying to gauge the feeling of the body. And then alternative 2 was that concept of the 207 and 3.04.5, where we talk about the longer stay and having somebody from the executive branch taking over, that those were kind of the 2 alternatives that the board wanted to consider. I had to list all 3 on the agenda because you laid over all 3 items, and that's kind of why they're there. But my intention kind of in having the 2 amendments was to say, this is one kind of using the existing model of stays, but instead of being absent from the city, it's 5 business days. And then model 2 was that longer stays, executive branch is able to act as mayor for a period of time. We keep giving Mr. Reddick credit or blame for it. Exactly. But that's kind of what I was hoping to do by writing those things. But obviously, you can choose to amend anything you want.
So I would like to stand on my motion, and it was seconded?
It was.
Who's second?
All right.
Need a vote.
Bonet.
Before we vote, are we voting in the affirmative if we would like to repeal, or are we voting in the negative?
Yes.
Vote in the affirmative if you'd like to reconsider.
Okay.
Ready? Bonet.
Yes.
Fox.
Yes.
Kauth.
Yes.
Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell.
Yes.
Plucker.
Yes.
Perstai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion passed.
Then Julia, maybe what would be appropriate is if you and your committee would want to walk through the concepts and get an informal support to gauge it, and then we can cobble together a resolution if that's appropriate, Mr. Chair.
Yeah, I'm trying to think if that's a good way to do it, or if, I think we need to have a discussion on what we all want.
Yeah.
But, God, I hate to do this, but maybe send it back to the law department to rewrite it into one motion, and then come back in a couple days.
There is one piece that after some further discussion after reviewing some information that was passed on to me, we may not be able to do acting mayor from the cabinet as it stands. There's information that we would have to consider, particularly prescribing that person could be the mayor as it says in the charter, which already talks about where they live, their residence, all that kind of stuff. So if everyone in the cabinet is not living in that address necessary, that would disqualify them. It may end up going back to the city council anyway. I believe that.
And that's language is addressed in that reference to 3.02.
Right. We would need, so we probably should just remove that piece of it for right now. I think discussing the emergency power and the other parts of it that would prescribe more to what happens in 5 days, what happens with the request, and disabled is probably a better discussion. So let's maybe have that discussion without the acting mayor as a thought process.
That would then leave the option that I think the entire subcommittee, looked at length, which is C1, which is the mayor can be gone for 5 business days without transferring power to the president of the city council. It has the emergency provisions in there that Mr. Indenbosch drafted that I feel comfortable with. And the third, which changes the disability from the language in the charter now to mirroring what they do at the federal level.
And Julia, I think, I'll just give my 2 cents really quick. One, I would support that because I think it seems to be a consensus of the body. Some people didn't want any 5 days. Some people wanted a longer period of time. 5's a compromise. You have the disability modernized, and then you also have that emergency thing just in case. I think that's reasonable.
I would, not having been involved in the discussion of the subcommittee, and I have to tell you, after listening to the discussion of it in the last meeting, I was sitting there really confused. And I'm even more confused now because we have so many options, and now you want to split it off and do even more options. I would like to see it well written out before I do any vote on forwarding anything to the city council. It needs to be, if we're going to do a debate on it, let's finish the debate today. But that would be just about all we would get done. I don't feel comfortable on voting on it. It sounds like scrambled eggs right now.
Press side, and I think some of that's just from confusion of having so many options, but I think and I don't want to put words in your mouth, so please feel free to jump in, but what Ms. Plucker and Mr. Kennedy was referring to was the last amendment we had received from Bernard of alternative to 5-day period and change in disability language, and then the title gets too long for my iPad, where it covers all of those different pieces in sequence in writing.
And I would agree. I mean, I respectfully disagree with Ms. Bonnet. I think we had considerable discussion at the subcommittee level. We had considerable discussion at our very first charter meeting altogether, that's where we heard, as Mr. Kennedy alluded to, some people weren't comfortable with any days, some people were comfortable with longer. And then we had considerable discussion last meeting where it seemed like we had general consensus, but we wanted to see the language of the emergency issue. And I think Mr. Indenbosch has presented that. It's not that difficult to follow those situations where the emergency may arise. And that is all laid out in C1. And if there isn't further discussion, I would make a motion to approve or to send that forward to City Council, C1, which is 2.07A and 2.07B.
Okay, is there a second?
Do we need to open that up for public first?
Yeah. Oh, yeah. I keep forgetting about that. Public hearing,
I've already had them on all of them.
seeing none, public hearing's closed. Any further discussion by the committee?
I have a question. I have several files here, and I don't know which one to open. To
Okay.
be able to read the text.
It's.
Bernard, maybe you ought to explain a
Okay.
little bit more. The way I see it, you've got
So
2.07.
I sent you, so there were 2 amendments added to the agenda from the last time. One of them, and I sent revised versions to you this morning. One of them references 2.07 A and B in the title, and one references 2.07 and 3.04.5.
That last one is not what we're voting on.
No, we're voting on the first one, which is the proposed amendment to 2.07A and 2.07B, and it's on the agenda as 4C1.
And that,
It would have been easier if I'd have just destroyed your agenda, probably, but.
and I guess to clarify a little bit for the committee, the way I understand it is 2.07A has the language of 5 business days, but then it goes on to include a language with respect to emergency. Is that correct?
Yeah, that's fine.
They're all on the same?
Yes.
Same item? Okay. Then we have a motion and a second. Discussion.
This is the one, she's gonna try to show it.
Oh, thank you.
That's one we're going to vote on.
How do I do that? This is the one that we're,
Scroll through that quickly so we have both pages.
well,
Make sure it's the same one.
that's all the changes are on this page.
Right.
The only part that's deleting is on this.
And the strikeouts.
And
also.
strikeouts.
Yeah.
The deleted, and that's the second page.
Yep.
That's a really clean version too, I think.
And just to confirm, Bernard, this is from the email from 9:28 this morning, correct?
Yes.
It had only 2 attachments.
Yes.
And we're looking at the one with just A and B.
Correct.
The other one has A, B, C. We're not looking at that one. I just wanted to make sure everyone's
So this is
on the
the
same
item,
page
just
clearly.
to show it, anybody can look at the screens, and you can see that we have the changes to the 5 business days. The area, the stuff that is highlighted in yellow, which is the emergency language, and then the changes to 2.07B are to comply with, or make it consistent with the 25th Amendment.
And just to clarify, only the yellow language is new to this meeting. We had the
Correct.
language of 5 business days at the last meeting, and we had the language of the
Correct.
disability.
I highlighted it for purposes of allowing the committee to look at it to make sure they were okay with my scribbles.
Correct.
But we are voting on all of it, it's underlined.
Yes.
Correct.
This is the item that there's been a motion and a second to approve.
I'd also like to add, Sotolongo, that, I think there were some concerns that we discussed last time with the acting mayor portion, that the mayor gets to choose their own, and it didn't match the emergency process and the line of succession there. I think we've handled that issue now by just sticking with the emergency line of succession, which addressed concerns that people said, I didn't vote for these people, blah, blah, blah. I just want to say that, too. I think that helped ease those concerns as well.
Okay, see no other comments? We'll do a roll call here in a second.
And we are out of order on the agenda. We understand that. Oh, that's what our issue is. Okay,
We're good.
ready? All
Yeah.
right.
Bonnet,
Yes.
Fox,
Yes.
Kauth. Kennedy. McPherson,
Yes.
Morgan,
Yes.
Pendrell,
Yes.
Plucker,
Yes.
Prestai,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado,
Yes.
Sotolongo,
Yes.
Kratz.
Yes.
Oh my
Motion
golly.
passed.
Now, I guess the next item,
I wish I'd have known how to use that. I just learned how to use it. I should have done it before. We still need to go back and clean up, I think, 4B, and that's the one you originally adopted and presumably voted down.
Yes,
And
so,
4D, do the same
so
thing.
4B, we voted down, that's
And then-
it.
And then vote 4D down.
And now 4D, is that the one that has the language on the acting mayor, 3.04.5?
That's fine, if you don't want to take it up, if you,
Yeah,
all right.
it does. Make
B
it
and,
easy.
B and D are gone. Moving right along.
And now, Bernard, we've got two sections on acting mayor, 3.04.5. One has some additional language that apparently was added.
Yeah, so that's the, I think that's the position, the change that you guys have abandoned. I did add emergency language to that particular provision, so if you're gonna go in that direction, the new language was to add emergency direction, but it's my understanding that it's the whim of the convention not to move forward with that.
Correct.
Is that correct?
Yep.
Then on both these, we would have to have a motion to deny.
It'd be cleanest
Yes.
to have a motion to deny 4B and then to deny 4D.
I would make a motion to deny
I would second that motion.
4B. Sorry.
You're gonna do both or just one?
No, I
can-
jumped in there.
Can you do both at the same time? I would make a motion to deny 4B and 4D.
I second that motion.
Okay, roll call.
Bonnet.
Yes.
Fox.
Yes.
Kauth. Kennedy. McPherson.
Yes.
Morgan.
Yes.
Pendrell.
Yes.
Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Aye.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion passed.
Okay. If I have this correct, the next one is Charter Section 2.18.
2.18, yes.
Okay,
This was a recommendation, a proposed amendment from the city clerk. There were actually several amendments. I think after the discussion we had at the first meeting, there was some decision not to move some of them forward. This is one that we are moving forward to you. It requests that you amend 2.18 to require publication as opposed to in each of the daily newspapers. The city has, through a different charter provision, a designated official city newspaper, and this would require publication in that newspaper as opposed to attempting to define what are the daily newspapers in general circulation and having to publish it in multiple sources. I know this was a recommendation from Ms. Butler as well.
you open a public hearing. Seeing none, we'll close the public hearing. Comments from the committee? Is there a motion from the committee? Has to be a motion.
Second.
Is there a second? Okay. Let's do a roll call.
Bonnet.
Yes.
Fox.
Yes.
Kauth. Kennedy. McPherson.
Yes.
Morgan.
Yes.
Pendrell.
Yes.
Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion passed.
Okay, the next and I guess final amendment, proposed amendment, is section 8.13, which deals with reconstruction of government in event of disaster. Bernard, you want to?
Yep, this was a recommendation that came out of one of the suggestions from the mayor. I already can see one potential change that some of you may want to make, but we'll talk about that in a moment. Basically, the concern was that if there was a single event that took out the mayor and the entire council, all the other situations are discussed. If there's at least a portion of the council, this is intending to address that situation where there's a public disaster in which both the mayor and the entire council would not survive a disaster. Puts, and frankly, trying to figure out an alternative was to put the members of the mayor's cabinet in the position of acting mayor till such time as the mayor and the council can be, till the next election that would be held. And in order to discern between which members, I did it who had served the city the longest. As I said, the other caveat that probably should be added is there should be some recognition that any person appointed shall meet the qualifications in section 3.02 of the charter, which is being a resident of the city. So if this is something that you are considering, I might make that, propose that as a friendly amendment.
I'd like to make an
Wait,
amendment.
wait. I'm going to do a public hearing.
Oh, there you go.
I keep forgetting to do that, but this time.
You're gonna do it.
Okay, public hearing. Anybody want to comment? Seeing none, we'll close the public hearing. Mr. Kennedy.
Yeah, I'd like to, I think first we have to open this up before we make any amendments. So I'd like to make a motion to approve as presented, City Charter Section 8.13.
Is there a second?
Second that motion.
Okay. And then I think Bernard's suggesting that we make an amendment.
Then I would like to make a motion, make an amendment to add the provisions as stated by legal counsel concerning that they meet the qualifications to be able to serve as mayor according to the charter and state law.
Second.
Bernard,
Sotolongo.
Bart,
They were wrestling for the privilege.
do you want to add anything more? Do you
No,
have the
no,
language
sir.
that you want?
Nope, I do.
Okay. Discussion. Motion. Okay. Wait, we need a motion on the amendment.
No, we have it all. We just,
Yeah.
should be a vote on the amendment.
Okay. Just do a vote on the amendment then.
Bonet.
Yes.
Fox.
Yes.
Kauth.
Yes.
Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell.
Yes.
Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion passed. Now it's a vote as amended.
Now we need to,
We got it all. It's just a vote as
I
amended.
think I voted yes.
As amended.
so we're
But-
done with the charter
No, you gotta do
amendments.
it.
No, no, no.
You gotta be
One more
vote.
vote. I'm gonna
I said
go.
we did.
No, we're good.
Okay.
Bonet, this
We'll do
is the vote as amended. Yep. Bonet.
Yes.
Fox.
Yes.
Kauth.
Yes.
Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell.
Yes.
Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion passed.
Okay, we've completed this, items listed in number 4, which are the proposed charter amendments. Next item on the agenda is recommendations to the city council, not charter amendments, but just suggestions for legislation.
And I did.
And I'm not sure how you want to proceed with this section.
Well, I thought I would start with an introduction, and then you can go beyond what you guys want to do. I did receive 2 requests from members of the Charter Convention since I sent out the solicitation late last week. One suggestion was by Ms. Kauth to extend that the city should support a bill to lengthen the residency requirements in state law for mayor and city council. So that was one recommendation. And the second recommendation that I received was from Mr. Morgan, and that was a recommendation that the city council consider ordinances providing for rent control in the city limits. Those are the 2 recommendations that I received from members of the Charter Convention. I know that there's been discussions about other things at various times, but those are the 2 items, and I leave it to you as how you want to handle those things. I don't know if other people have other suggestions, if you want to vote on individuals' suggestions.
Yeah, I'm kind of wrestling with this. I'm not sure I want to vote on it necessarily, but maybe we just simply provide those and list them.
Yeah.
And the other thing is we could frankly do is if individual members want to submit recommendations, I can identify in the report who makes the recommendation and what the recommendation was so that there is a list. Again, up to you. I'm here to serve you on this one.
I think there's 2 different areas. So if the board wanted to submit to be part of a formal record of what they individually thought, I have no problem with that. I may not support rent control or be for it. I mean, that's one thing or another, but I think if you're a member of this board and you have an issue, I think the council should hear what your individual idea is. So I support both recommendations being there and anything else that's forwarded. The second piece is this. I know Mr. Dodge has been here for a lot of times and other people have taken the time to come here. So I would also forward to the, as far as our report, I would give the transcripts and the letters as part of the record formally to the council. So they have the ability to see for the public that took the time to participate and give input either orally or by mail, that the council would have access to that and say, the community that did participate in this process, either by email or in person, this is what they had to say, because I think that's important. If you took the time to come here and say something, and thanks, Wes, for coming, but I think you got to give that nod to the people that did participate in the process, because a lot of people didn't do that, and if they had something to say, they should have done that, and I think you give a recognize to them, so.
And
I'd be
I
comfortable
will
with that.
assure you that in the report that ultimately is prepared, it will include not only the transcript of the proceedings, but I will also include the recommendations that we received from members of the public.
Yes.
That were shared with all of you will be part of that report.
So maybe we vote that that's going to be what we'll do, and we'll give a deadline for board members to give to your office anything else that they would like to submit as an individual member.
Yeah, Mike, I don't particularly want to go through each of these and vote on them.
No, I don't. I don't
And
either.
So support or not support, but yeah, maybe 5 days for the members to present something to?
Say by Monday.
What, by Monday?
Can I get a point of clarification? When you say recommendations, you're not talking about new recommendations for amendments, but rather recommendations on the procedure that we followed, concepts of how to
No.
make it smoother, better?
Just for legislation,
I
which I guess could be.
I think you're correct that in your first observation, we're not talking about potential charter amendments. These are other things that you might like the council to consider. A number of the public suggestions we've had really were legislative in nature more than charter in nature, and this would be an avenue for some of those things to be on there. We had a lot relative to affordable housing, for example, and that may be a recommendation that someone wants to make. But so these are just observations from the members of the convention to the council, but they would not be additional charter amendments.
And then, so is there another title that we should give to recommendations for how to improve public participation in the whole process of the convention, how to improve the flow of information, how to make your job easier, Bernard, and things like that? I had a few that I put into some of the emails I sent you, but I also have some that in watching from afar, watching how the process went, that I think there are a couple of points that I think would help everyone feel more comfortable with the whole process, especially if someone new comes onto the next charter convention.
Yeah. So I would say, I mean, obviously, to the extent you want to give feedback to how we conducted it, our office, I don't know that necessarily needs to go to council, but if that's what you want to do, that's fine. I mean, we can certainly give feedback about certain things, or feedback about putting certain things on the website or whatever else. If there's more broader process things, I mean, I guess I would say, I don't know that recommendations to the council need to be very specific. Mr. Indenbosch should have done such and such.
Oh,
or,
no. I'm talking, nothing
I'll tell the
personal,
council that.
nothing personal. It's just process. It's just process.
But again, I mean, I think any of those things are fair game.
Okay, thank you.
So by next Monday, if any of the members have legislative suggestions, get them to Bernard, and that'll be part of our report also.
And I'll prepare a summary and circulate it to everybody so that you see it before it is made available to anybody else.
And on the agenda, next meeting, if necessary, is July 14th. I don't think we need another meeting.
No.
Bernard will put the report together and pass it on.
Before we wrap up, Chairman, I apologize for not getting this ahead of time, but I had one last amendment. I promise it's short and sweet, so when you make a lot of changes, but it would be to section 8.02, civil rights. It wasn't assigned to any specific committee, and it says all persons, regardless of race, creed, color, sex, or national origin, shall have equal enjoyment of and equal protection under all the provisions of this charter and all ordinances, resolutions, rules, regulations, orders, and directives adopted pursuant hereto. And would like to make a motion that we amend that to also include sexual orientation and gender identity to match the current ordinances passed by the city.
I believe the city ordinances already have that language in it with respect to those
They do.
additional items. I'm trying to recall exactly what it says.
They do. As you recall, we had
I know we had an issue some number of
it
years
was
ago.
about 10 years ago that we
Yeah.
made those amendments and included that language. So I think what Mr. Pristad is saying is he would like the language in the charter that lists the protected categories to mirror that's in the city ordinance.
Yeah, it's similar to the conversation we had on the 6-month limitation on office holders, or 6 months minimum to be considered for the office of mayor or city council. Similarly, updating the city charter to reflect other elements of law.
Okay. I guess we'll go back then a little bit on our agenda. You've heard the proposal. Public hearing? Seeing none? Committee members? Thoughts, discussion?
I just would want something, I'm not against the idea, I know what we put in thing, I just want, from council to city attorney, does this have any effect, or I know we have laws in place, so if it does, I just want to make sure we're not doing something that this body is opening up a can of worms.
Well,
I'm inclined to vote for it, but I just want to hear an opinion.
Well, I mean, as a practical matter, the city code can be amended by the city council anytime that they want. If a charter amendment can only be amended by purposes of a vote of the people. So yes, it would be mirroring what city law is, but obviously it would be measurably more difficult to make those changes. You could presumably have a council go in and remove those categories right now just through an ordinance. If these were to become part of the city
Then you have
charter.
Federal protections that are, and state protections
We do.
already there.
Yeah, I mean,
I do think this sends a message, though,
Yeah.
as a city. And I think if we're going to be representative of the people, we need to ask ourselves, what messages do we want to send? I personally would vote for this.
I agree, I just want to ask the attorneys, does this do something that we may have an unintended consequence? If not, I'm going to vote for it, so I just.
It's just a matter of harmonizing the terminology, correct?
Well, it's certainly to make the language consistent between those documents. I mean, it does ultimately make a change in that regard. The language in chapter 13 dealing with civil rights actually only protects certain categories, public housing, and again, I wasn't aware that this was going to come, so I haven't done a lot of research, but I drafted the original ordinance, and it deals with the language in chapter 13, which is the language where we adopted sexual orientation and gender identity, includes public accommodations, public housing and service. Potentially, if you add it to the charter, has a broader implementation, but it would also be consistent, I think, with what we've currently seen in how federal law has been interpreted as well. So I'm not sure it does anything more than square our charter with how.
Yeah, and we apply that in my school board because we have the federal laws and all that. I just want to make sure from the city thing, you guys are fine with that. Otherwise,
I don't see any. I don't
Okay.
have any objection.
all I care about.
Quinn here, I think it does more than mirroring too. As Mr. Reddick said, it sends a pretty strong message of inclusivity.
Yep.
That I think we're all trying to.
Yep. And it's certainly an issue that's probably more important than in some other times to try to send.
Other comments or motion?
I'd motion to approve the section 8.02 as amended.
Second.
Second.
And that includes what additional language?
Sexual orientation and gender identity as protected categories.
Okay. Let's do a roll call vote.
Bonnet,
Yes.
Fox,
Yes.
Kauth, Kennedy,
Yes.
McPherson,
Yes.
Morgan, Pendrell, Plucker,
Yes.
Fristine,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado,
Yes.
Sotolongo,
Yes.
Kratz.
Yes.
Motion passed.
Okay. That should be it, unless somebody wants to bring up another item.
I just got one question, sorry, guys. In writing the recommendations, as far as I have a huge issue with the state mandated recommendations, I know we can't do much about what the state says. I guess I don't want to waste any more of my time and beating a dead horse. And is that even something that the city council can change, can go to, is that a state thing? Do I have to call my senator? I mean, what would you recommend I do? Because I don't want some Western Nebraskan, dictating what we do in Omaha. Is that something that it's even worth fighting for or asking to change in our city's charter?
So the reality is, yes, state law prevails over city ordinance and city charter in most regards. If there are changes to state law that you think are necessary, that have come up during the conversation, obviously the city council can't change state law, but what what you can encourage the city council to do is to support legislation that would change the laws as to such and such, whatever topic it is, because the city does put together a legislative package every year of bills that it endorses and it supports. You can make those suggestions to the city council, and they obviously then could choose to proceed with a bill that you recommended, or if somebody else were to introduce a bill that was similar, endorse it. Not binding on them, but you're right that a lot of things are based in state law, but there is an ability to request that the city council support amendments to such and such, if that's what you want to do it. That's frankly probably the extent of what we can accomplish here.
Does that answer your question? Good. With that, I think we'll adjourn, but before we do, I want to thank the committee members for their efforts, the time that they put in, as I know it's all volunteer time, and I think we all appreciate that. And finally, want to thank the law department, particularly Bernard Indenbosch, that did a lot of work and guided us through this.
Well, and I want to thank all of you. I mean, I always talk about, this is one of the things I enjoy most in my job, because we have 15 different people. Many of you have extremely different and difficult, but extremely different political positions. But yet, I'm always amazed when you have people with the diverse political opinions get into something like this. You can have reasonable discussions, even with disagreements, and amazingly even come to consensus on things that I never thought was possible. I never thought Paul Kratz would ever endorse anything that allowed the mayor to have power while she was out of office, but yet you managed to make him do it. So
I almost voted no on that.
I figured you did, but did you hear my gasp when you did? So I do appreciate it, and I think this is, I appreciate that, and I appreciate how everybody worked together. It makes for a fun experience.
With that, we're
And
adjourned.
Mary as well for having to.
Thank you.
School board meeting now. Back to back.